The first thing I noticed was how neat everything looked. That should have reassured me. Instead, it made me uneasy. Evidence rooms are never truly orderly. They're functional, sure, labeled shelves, barcodes, chain of custody logs, but real systems carry scars. Smudges where tape was pulled too fast, handwritten corrections in margins, a faint sense of human fatigue layered over procedure. This one was too clean. I was assigned to the case review unit 3 years after the conviction. The mandate was narrow. Identify procedural weaknesses in closed cases that might create exposure if challenged. Not reinvestigate guilt, not reopen facts. Just ensure the record could survive scrutiny. Most files passed quickly. This one didn't. The case involved a homicide from 12 years earlier, a late-night altercation outside a warehouse district, a single suspect, a swift arrest, a confession that had never gone to trial because the physical evidence seemed airtight. I wasn't looking for innocence. I was looking for mistakes. The evidence inventory listed everything you'd expect. Weapon logged, clothing sealed, forensics cataloged, photographs archived, digital backups cross-referenced. Nothing missing. But as I cross-checked the physical ledger against the digital system, I noticed something subtle, a gap that didn't register as an error, just an absence. Item 47B, transferred, logged, never returned, not marked destroyed, not marked retained, just gone from the process. At first, I assumed clerical oversight. These systems were built by humans after all. Humans misplace things, they mistype, they forget to close loops. But clerical errors usually leave fingerprints. This one didn't. I pulled a handwritten log, the old one, bound in faded blue fabric, kept mostly for ceremonial reasons now. The pages smelled faintly of dust and toner. On the entry corresponding to item 47B, a signature appeared where it shouldn't have. Not the officer who signed it out, someone else, a technician. That was unusual, but not impossible. I wrote it down and moved on. I should have stopped there. Instead, I kept going. When you work long enough in systems designed to prevent failure, you develop a sense for when something didn't fail. It was simply ignored. There's a difference. Failure leaves damage. Neglect leaves silence. This was silence. I requested the archived emails associated with the case, not because I expected to find anything dramatic, but because routine correspondence often explains routine deviations. A delay, a reassignment, a vacation. The inboxes were sparse, too sparse. One message caught my attention. A single line, sent internally, years ago. Item transferred per standard. No reference, no follow-up, no reply. Standard to what? I flagged the file and brought it to my supervisor. He skimmed it quickly, nodded once, and told me to document the inconsistency. No instruction to escalate, no instruction not to. That was permission enough. The hearing was scheduled months later, after the defense filed a motion alleging evidence mishandling. They didn't know what they were looking for. They just suspected something had gone wrong. I sat in the gallery during the pretrial motion, legal pad on my knee, pen uncapped but unmoving. The defense attorney spoke carefully. He didn't accuse the department of misconduct. He suggested uncertainty, raised the possibility of contamination, asked for clarification. The prosecution responded with confidence. All evidence accounted for, all procedures followed, chain of custody intact. That word again, intact. Then I was called, not as a witness yet, but as a custodian of records. I explained my role, my assignment, the scope of my review. I spoke slowly, deliberately, not because I was nervous, but because precision mattered more than speed. The judge listened. He asked me one question. Is there evidence that evidence was mishandled? I paused. No, I said. There is evidence that a process ended without resolution. The courtroom shifted slightly, not dramatically, just a collective recalibration. The defense seized on the phrasing, asked me to explain the difference. Mishandling implies error, I said. This appears to be omission. The prosecution objected, overruled. I explained how item 47B moved through the system, how it was logged correctly, how it left the primary evidence room and entered a secondary analysis phase, and how it never came back. The judge asked where it went. I don't know, I said. That answer carried more weight than it should have. A recess was called. In the hallway, attorneys whispered urgently. Phones came out, emails were sent. Somewhere in the building, someone was probably digging through old storage rooms, hoping to find a mislabeled box. They didn't. When court resumed, the prosecution requested a brief continuance. Denied. Instead, the judge ordered a full evidentiary hearing. That's when the tone changed. Evidentiary hearings aren't dramatic. They're meticulous, slow, almost tedious. Each witness is questioned not for narrative, but for process. Who touched what, when, why? The technician who signed the log was located, retired, nervous, cooperative. He testified that item 47B was sent for secondary testing at an off-site lab. Standard procedure at the time, he said. The lab records were requested. They showed no receipt. The prosecution argued that absence of documentation did not imply absence of evidence. The judge disagreed. Documentation is the evidence, he said quietly. That sentence landed harder than any verdict. Over the next days, more testimony followed. Supervisors, clerks, analysts. No one lied. That was the strangest part. Everyone told the truth as they understood it. The system hadn't failed because someone was malicious. It failed because no one noticed the silence where confirmation should have been. Negligence doesn't wear a villain's face. It looks like routine. By the final day of the hearing, the courtroom felt exhausted. The defendant sat quietly, hands folded, expression unreadable. The victim's family sat behind the prosecution, eyes fixed forward. The judge took time to review his notes. When he spoke, his voice was even. The court finds that the integrity of the evidence cannot be confirmed, he said. Without confirmation, reliability is compromised. The conviction was vacated, not overturned, vacated. A legal distinction with human consequences. There was no cheering, no outburst, just a slow exhale that seemed to pass through the round like a draft. Outside the courthouse, reporters waited. Questions were shouted. The defendant walked past them without speaking. The victim's family was escorted out a different entrance. Later, in my office, I closed the file. The system had done what it was designed to do, eventually, but I couldn't shake the feeling that the truth hadn't emerged, only the gap. Mysteries like this don't resolve neatly. They leave you with something worse than uncertainty. They leave you with the knowledge that certainty once existed and was misplaced.